Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a case law. Of course, the judgment is reserved regarding the enrollment of advocate who got the law degree from a derecognized law college. Friends, you all know, according to section 24 of the Advocates Act 1961, there are three criteria to become an advocate, to get enrollment as an advocate, the process of advocacy. Number one, you should have passed the law degree from a recognized university. This is more important. A citizen of India or having completed 21 years, they are all there. But as far as our point is concerned, you must possess a degree from a recognized university. University means a group of colleges, means a recognized college. But here he got the law degree from a derecognized law college. You can read the case as Bar Council of India versus Rabi Sahu. Bar Council of India versus Rabi Sahu. This Rabi Sahu, he studied law and he wrote the examinations from a derecognized college. What happened is the college was running, but you may be knowing, according to section 7 of the Advocates Act, you may be knowing the functions of the Bar Council of India. So, as per the functions, the powers and functions, the Bar Council of India can inspect any college, can recognize any college, can derecognize any college also. When the college was going on, they have conducted the surprise check, they have conducted all these things. Ultimately, they derecognize the university. Now, what about the fate of the person who studied in that particular law college? This is the important problem. ఇక్కడ డీరికగ్నైజ్ చేసినప్పుడు అడ్మిషన్స్ గురించి ఆలోచించాలి. Already people are studying. What about their fate? So simply you cannot say, since you have studied in a derecognized college, I cannot enroll you as an advocate. The problem is that you have allowed them to study in the first year. No doubt they have mismanaged the management ఏదో చేసింది. This is వేరే సంగతి. But what about the students? In Karnataka, I think 2 years back, Karnataka state, what happened is BCI derecognized, but the University Grants Commission, UGC, they have recognized. There was a clash. Then the Supreme Court allowed the boys to get enrolled as advocates. So such problems will be coming. Right? So in this connection, please remember the famous case of V.Sudheer. So this is also V.Sudheer versus Bar Council of India, 1999. So where Supreme Court stated that the Bar Council of India cannot prescribe any extraordinary rule except the legal education rules or except according to section 24 of the Advocates Act. Therefore, people who used to get enrollment as advocates basing on Sudheer judgment. I think very recently, about 2 months back, Supreme Court has overruled Sudheer judgment, V.Sudheer judgment, stating that Bar Council of India is omnipowerful or Bar Council of India is competent to make any rules regarding the conduct of All India Bar Examination. At that time, this judgment has been overruled. Right? So here the point is, when the he was derecognized, this boy, he applied for the enrollment. It was rejected because the college is derecognized. Then he moved to the High Court. High Court also did not agree. Ultimately, High Court said, no, BCI has to enroll him because he has already studied, he has got a degree. Agreed by the order of the High Court. Now, BCI approached the Supreme Court. Incidentally, when the matter came before the Supreme Court, the other side, the educational institution, or the so-called derecognized law college, nobody represented except this Rabi Sahu. Therefore, 2 judges bench, Justice Vikramnath and Sanjay Kumar, they reserved the judgment. Of course, the question is whether the BCA has got power to regulate matters of legal education or not. So, please remember, BCI can interfere pre-enrollment and post-enrollment also. This you have to remember. ఇది మర్చిపోకండి, ఎందుకంటే నార్మల్గా విల్ బి అండర్ ది ఇంప్రెషన్ అడ్వకేట్స్ యాక్ట్ ఎప్పుడు అవుతుంది, అడ్వకేట్ అయితే వస్తుందనే భావనలో ఉంటారు. అది కరెక్ట్ కాదు, రైట్? సో ప్లీజ్ రిమెంబర్, BCI stated that there are 48 law colleges which are derecognized during the particular academic year. So therefore we can't get them enrollment as advocates. So now Honorable Supreme Court of India reserved the judgment. So here two important points you have to note. Section 24, whether you have to get a degree from recognized college or not. Number 2, by mistake you have studied in an unrecognized or derecognized college, what about your fate, whether you can get enrollment or not? As far as this is concerned, no. Okay, right? If you know this much, it is sufficient. Thank you.